Friends, in a landmark judgment today, the Honorable Apex Court dismissed the Union of India's appeal in the matter of whether GST was payable in reverse charge basis on transportation of goods by vessel, popularly known as GST on ocean freight. Hence, the Apex Court pronounced that no GST would be payable on the services of transportation of goods by vessel as notified by entry number 10 of notification 10/2017 IGST on transportation of goods by vessel from a port outside India up to the port in India. The arguments of the respondents in the case was also that whether the GST Council's recommendation on taxable event, taxable value, tax rates, etc. were binding. The learned ASG submitted that the GST Council had the power to make laws under GST, whereas the respondents' councils argued that GST Council's recommendations were only persuasive. The same was also upheld by the Apex Court today, which noted that the GST Council's recommendation were only persuasive and not binding, and the center and the state had equal powers to make laws under GST. In case the center and the states are not giving equal powers, it would disrupt cooperative federalism in the country. Further, the Apex Court ruled that in case of import of goods on CIF basis, the value of the import of goods consists of cost, insurance and freight. Hence, it is a composite supply under section 2 subsection 30 of the CGST Act of goods. To carve out shipping service on ocean freight from such composite supply of goods would be violative of section 8 of the CGST Act, and therefore no GST would be payable on import of services in case of ocean freight. The Honorable Apex Court also ruled that on a conjoint reading of section 2 subsection 11 section 13 subsection 9 of the IGST Act along with section 2 subsection 93 of the CGST Act, import of goods was an interstate supply of goods and the value of the services was embedded in such interstate supply of goods. Further, it held that the GST law did not specify a taxpayer in case of GST on ocean freight which was other than the tax recipient or the supplier of the service. In case of import of the goods and GST on transportation of the vessels, the supplier of the service of transportation by vessel is the shipping line, which is not the taxpayer in RCM in the case, and also the recipient of the service is the foreign exporter, which again is not the taxpayer, but the taxpayer over here as notified in notification 10/2017 IGST Act is the importer. To make the importer a recipient of the service other than the recipient and the supplier of the service, a separate rule should have been made under section 9 of the under section 5 of the IGST Act. This is a landmark judgment, and all the taxpayers who had paid GST on ocean freight under protest earlier can now seek for refund. However, the final order of the apex court is pending. One must read the final order, and we will analyze the same also in our coming 11th colloquium on indirect taxes on this Saturday 11 a.m. to 12:30 p.m. Thank you very much.